Good afternoon, everyone. Thanks, Kathy. Welcome back to our weekly webinar here, another Tuesday, another sunny day here in Syracuse, where I'm sitting to host today. Before I introduce today's presenters and go over our agenda, I wanted to give a heads up to a complimentary webinar that we're going to be holding tomorrow. It is about a recent decision that came out of the National Labor Relations Board finding that a college basketball team, the players are employees and can form a union. So really an astounding decision from the NLRB that could really send shockwaves through college athletics. And so we're going to hold a pop-up webinar for our clients, obviously those in higher ed. This is of great interest too, but maybe if you're just a college sports fan, you might want to tune in out of general interest. So that'll be tomorrow at noon. You can see there's a register here thing on the slide. I don't think that you can click on it in this format, but if you go to our website, bsk.com, you can certainly find a link there. And if you're on our mailing list, you may have received an invitation for it. So it's free for our clients and for our friends on this webinar. And so hope you can join us tomorrow. It will be presented by Pete Jones, who many of you know from this webinar, Tom Iran, who's also a frequent presenter, and Rick Everard, who's out of our college athletics practice out in Kansas City. So looking forward to that tomorrow. Then if you can move to the next slide, let's talk about what we're here to cover today. I know we usually have 4 presenters. Today we have 3. It's quality, not quantity today, right? So we may finish a little early, we may not. But here's the lineup. We have Subha Viswanathan, who is a frequent presenter, continuing his series of Wage and Hour 101 with some just basic concepts that are important to understand for all employers. Then we'll move to Kim Wolf-Price, who has not presented on this. Kim is Bond's Chief Strategy and Diversity Officer, and will be talking to us about a pending amendment to our New York State Constitution, something that does not happen very often. And then we'll move on to an employee benefits topic, continuing our frequent discussion of ERISA this year during our 50th anniversary of ERISA celebration. And Devin Carris is here to talk about an issue in that area. So without further ado, let's turn it over to Subha to talk about how you calculate the regular rate for purposes of overtime when you have incentive compensation in there. So Subha, good to see you today.
Kristen. Yeah, as Kristen said, an issue that's come up a couple of times over the last couple of weeks for our clients is how to go about including bonuses and commissions in the regular rate for overtime computation. So I thought it would be a good topic to review. Next slide, Kathy. Just to kind of review the general law in the area, under the Fair Labor Standards Act and under the New York labor law, employees obviously have to receive at least minimum wage. Non-exempt employees have to get minimum wage. And they also have to be paid time and a half of the regular rate for all hours worked over 40 in a work week. So what exactly goes into the regular rate? It's important to understand that it's more than just base hourly rate. It includes all remuneration paid to or on behalf of an employee, except for certain types of payments. And the general rule is if the payment doesn't fall within a specific exclusion to the regular rate, then it has to be included in the regular rate. So sums paid as gifts, for instance, if an employer gave everybody in the company $50 gift cards at Christmas time, that's purely a gift. It's not based on production. It's not based on attendance. It's not based on anything work-related. It's simply a gift from the employer. That can be excluded from the regular rate. Payments made for occasional periods when no work is performed due to vacation, holiday, or illness, and reimbursement for expenses can also be excluded from the regular rate. Discretionary bonuses, I'm going to talk in a second about what exactly constitutes a discretionary bonus versus a non-discretionary bonus. But discretionary bonuses can be excluded from the regular rate. Non-discretionary bonuses have to be included. Payments under bona fide profit sharing plans. There's a whole set of requirements regarding what constitutes a bona fide profit sharing plan for purposes of exclusion from the regular rate, which I'm not going to get into. But if you have a profit sharing plan, you need to make sure that it complies with the requirements in the regulations to exclude those payments from the regular rate for overtime purposes. Contributions to health insurance, pensions, generally contributions to any sort of third-party providers of employee benefits can be excluded from the regular rate. Extra premium compensation. So for instance, if an employer either has a policy or a collective bargaining agreement with a union that says that employees will get time and a half for hours worked over 8 in a day, it's not a legal requirement under the New York labor law or the Fair Labor Standards Act. But if that's set in a policy or a contract or collective bargaining agreement, that extra premium compensation can be excluded from the regular rate. And same thing if an employer, simply to incentivize people to work on weekends, has a policy that says if you come in on a weekend, you get time and a half of your hourly rate, that extra half time can be excluded from the regular rate. Any value or income derived from stock options can also be excluded. Next slide, please, Kathy. So what exactly does it mean if a bonus is discretionary? The employer has to have complete discretion over whether to pay the bonus and the amount of the bonus until a time very close to when the bonus is actually paid. There can't be any prior contract, agreement, or promise that would cause employees to expect a payment. It's not sufficient to have a written bonus plan, and in the written bonus plan have a disclaimer that says that the employer has a right to revoke, amend, change the bonus plan at any time. That's not going to magically convert the bonus plan into a discretionary bonus. It really has to be kind of an ad hoc, very random decision by the employer very close to the time when the bonus is paid to say, I'm just going to give a bonus and here's how I'm going to compute it. And there's no prior expectation that's created either in a policy, agreement, or promise. Next slide, please, Kathy. So most bonuses that employers provide are likely going to be considered non-discretionary bonuses if they're intended to incentivize production, efficiency, attendance, and to incentivize employees to remain in employment. So bonuses such as attendance bonuses. If an employee has perfect attendance for a quarter, they get a $100 bonus. That's a non-discretionary bonus that's intended to incentivize attendance. That's going to be considered non-discretionary. Any sort of individual or group production bonuses. So if there's individual goals, team goals, company-wide goals that are met, and the employer says if those goals are met, everybody gets a bonus, and here's how it's going to be computed. Again, that's going to be considered to be non-discretionary. Any sort of bonuses for quality or accuracy of work will be considered non-discretionary. And longevity bonuses. So this is something that employers don't always realize, that if they have a longevity bonus plan that says that somebody gets a bonus if they stay for a year or 2 years or 5 years, that longevity bonus, if it's intended to incentivize employees to stay with the company, that will be considered to be a non-discretionary bonus. And a bonus does not have to be paid pursuant to a written bonus plan for it to be considered non-discretionary. If there's a bonus that's given every single year, and employees, it's given with such regularity that employees have come to expect it and believe that it's an entitlement if they meet certain goals, or if the company meets certain goals, that they're going to get the bonus. That could be considered to be a non-discretionary bonus, even if there's no written bonus plan that actually memorializes whether the bonus is paid and how it's computed. Next slide, please, Kathy. So we're going to do some math in the next couple of slides. So if there's a non-discretionary bonus that's paid on a weekly basis, the math is easy. You simply add the bonus to the hourly compensation and divide by the hours worked in the work week to compute the regular rate. So by way of an example, let's say an employee works 45 hours in a work week at a $20 hourly rate. The employee also earns a $90 production bonus for the work week. The regular rate is computed by taking that $990 and dividing it by the 45 hours to get $22 per hour as the regular rate. That $990 already encompasses the straight time. It encompasses the straight time for the hourly rate as well as the bonus for all 45 hours worked in the work week. So the only thing that's owed in this computation is the extra half time, which is $11 per hour for the extra 5 hours that's worked. So that's an extra $55. The total compensation for the work week for this employee would be $1,045. So that's an easy example. Next slide, please, Kathy. If a bonus is paid on a monthly basis, the math becomes a little bit more complicated. You have to multiply the bonus by 12 and then divide by 52 to compute the weekly equivalent of the bonus. And then you divide that weekly equivalent of the bonus by the hours worked each work week during the month to compute the extra overtime owed. So let's say we have an employee who works 42 hours during the work week ending February 23rd, 2024. The employee earns a $364 production bonus for the month of February. The weekly equivalent of that bonus is going to be $84. So that's the 364 times 12 divided by 52. The regular rate increases by $2 per hour. So you take that bonus, divide it by the number of hours worked in the work week. That's the increase to the regular rate for the work week ending February 23rd. The extra half time would be $1 per hour. So the employee would be owed an extra $2 for that work week. So it's really important for bonuses that are not paid on a weekly basis. So let's say this bonus is paid during the first pay period of March. Once that bonus is paid, it's the employer's obligation to go back through the month of February, look at all of the work weeks that ended in the month of February, and recompute any overtime that might be owed to employees if they worked at over 40 hours during any of those work weeks. Next slide, please, Kathy. So if there's a quarterly bonus, you simply divide it by 13 to compute the weekly equivalent of the bonus. And then again, it's the same type of math. Once the bonus is paid, the employer has to compute the weekly equivalent and then add that weekly equivalent into the compensation for each of the work weeks in the quarter, and then recompute the extra overtime that's owed for any work week in which the employee worked more than 40 hours. So in this example, the employee works 46 hours during the work week ending February 23rd. The employee earns a $2,392 production bonus for the first quarter of 2024. The weekly equivalent is $184. So that increases the regular rate for that work week by $4 per hour. The employee is owed extra half time at $2 per hour for the 6 hours that are worked. So when that employee gets that $2,392 production bonus, the employee also has to get an extra $12 for that work week to compensate for the extra overtime pay that's owed. And similarly, any other work weeks within that quarter, the employer has to do the math and figure out what is the extra overtime for all of the work weeks in the quarter. If you have a payroll provider, they can probably do that for you, but they will need to know what the amount of the bonus was, and you need to make sure that they're computing the overtime accurately. Because simply having a payroll provider and trusting the payroll provider to do it accurately isn't necessarily going to be a valid defense, especially if you have language in that contract with the payroll provider that kind of, shifts liability to the employer for any payroll discrepancies. Next slide, please, Kathy. So I'm not going to get into detail on the annual bonus. It's the same concept. I'm kind of running out of time, so I'm going to Move on to the next slide. Commissions. So commissions are computed in the exact same way. And what we're talking about are non-exempt salespersons. So obviously outside salespersons who qualify for an exemption are not going to be subject to overtime pay, but any non-exempt salespersons, inside salespersons who aren't in a retail establishment, commissions have to be included in the regular rate, and you use the exact same method to include the commissions as you would for bonuses. Next slide, please, Kathy. So what is the potential liability if you don't go back and do these computations? Under federal law, the statute of limitations is 2 years. It's 3 years for willful violations. The New York statute of limitations is longer, 6 years. So an employer who doesn't include all compensation in the regular rate could potentially be liable going back 6 years for all of the overtime compensation that wasn't paid for all employees. And a lot of times we see these are sued as part of a class or collective action because these sorts of issues are ripe for plaintiffs' attorneys to seize upon and say, if there's a uniform policy of paying the bonus but not going back and recomputing the regular rate, a class of employees could be certified to file an action. And the potential liability for that 6-year period includes the unpaid overtime compensation, interest. It could include 100% liquidated damages of the amount that's owed, as well as if there's any recovery on the part of the class of employees or even an individual employee, there is a fee shifting provision that says that the employer pays the employee's attorney's fees. That's all I have, Kristen.
Thanks, Suba. It's easy to see how someone can get this wrong. I mean, it's not necessarily completely straightforward. And so thanks for that reminder of the importance of calculating the regular rate accurately. So moving on, we are going to go to our next presenter, Kim Wolf-Price. So Kim, as I mentioned, is our Chief Strategy and Diversity Officer here at Bond. And so many of you clients may not know Kim because she doesn't directly perform legal services for our clients, but she's extremely helpful to the attorneys here, helping us with professional development and diversity issues and lots of other things. So thank you so much. But Kim's also, is a licensed attorney and is very, very involved in the New York State Bar Association's Women in the Law section, right? So I believe are you the president of the section?
Yeah, I'm the chair of the section. Yep.
Great, the chair of the section. So she's the chair of that New York State Bar section and came back from the bar meeting this winter and was telling all of us about this New York State constitutional amendment. And so I thought it was worthy enough to share with our webinar attendees, and so invited her here today. So really thrilled to have you, Kim, kind of as a special guest, and appreciate your time. And so go right ahead with your presentation.
All right. Thanks so much, Kristen. Thanks for inviting me today. It's great to have the opportunity to speak with all of you. And of course, thanks, Kathy, for keeping this, you, Kristen, and Gabe, keeping this great series running. So thanks. Well, hello, everybody. The New York State Equal Rights Amendment, as Kristen mentioned earlier, it's not that usual that the New York Constitution gets amended. So right now we're giving you a little bit of a heads up. We want to make sure that you stay informed and ahead on information. So as Election Day approaches, November 5th this year, you're going to likely hear more about New York's ballot referendum on the Equal Rights Amendment. So Kathy, can we go to the first slide? Thank you. So I'm going to talk today just a little bit of a mini civics lesson. How did we get here? Give you a brief overview of the ERA language and talk a little bit about whether this passes, if this passes, whether there's going to be immediate changes to New York State law. All right, Kathy, next slide, please. All right, so what is a ballot referenda? It's a vote of the people of New York on a proposed constitutional amendment, but it's not all that easy to get there. First, that legislation must pass both houses of the New York State Legislature in 2 consecutive 2-year cycles. So that means this passed in the 2021-2022 legislative session, and then again in the 2022-2023 legislative session. Then in January of last year, immediately after it passed that second time, Governor Hochul signed it, and it was put on the ballot for November 2024. All right, first question. Don't we already have protections for women and others in New York's Constitution? Many of you might be thinking that. Well, currently the New York State Constitution itself does not enumerate protections for anything other than race and religious discrimination. This ERA proposed would prohibit discrimination based on a person's ethnicity, national origin, age, disability, and sex. Of course, maybe you're also asking, do other states have an ERA? And the answer is yes. They might not be exactly worded as ours is, maybe not as broad as this proposal is, but there are 29 state constitutions that contain these types of provisions, including just making sure that both men and women are covered and other different groups as well. The last state to do this was Nevada in 2022. So what that says is if you're doing business in a lot of states, you're already probably subject to some type of constitutional provision similar to this. This isn't something new or novel. Next slide, please. All right, so how did it get on the ballot? Just giving you a little bit of a background here. It passed pretty easily in both houses of the New York State Legislature, both times. You can see from the slide that the first time it passed the New York Senate 49-14, and then it passed the New York State Assembly 95-45. The second time, which was last year, 43-20 in the Senate and 97-46 in the Assembly, was not particularly something that had a big uphill battle or was close, like we see many of these bills or situations that we deal with in the legislature. The vote of the people will be November 5th of this year, and we don't often have these ballot initiatives. They are usually to change something in a state, city, or local entity's constitution, which is what we're talking about today. Next slide, please, Kathy. So this is it. This is the amendment. If it passed, it would amend Article 1, Section 11 of the New York State Constitution, which is the equal protection of the laws, discrimination, and civil rights. The change is we changed from having race and religion to this broader definition, as you can see here. So disability, age, and gender and sex are what are changed if this were to pass in November by a vote of the people. This is it. It's pretty short, pretty sweet to the point. It's just a little bit longer because we added the new sections. As you can see from Section B, just new laws can be made. It doesn't limit things. This isn't going to change what other things can be developed. Just means that if there's a violation of a discriminatory practice or potentially a discriminatory law that the government brings us, it'll be a higher standard of scrutiny. I know this is a lot of legalese and lawyer talk, but we'll get into that a little more. I just wanted you to see that if you hear a lot about this in the upcoming cycle, it's pretty short and it doesn't cover a lot. All right, so next slide, please, Kathy. All right, so is this an expanded definition? So this is the part that does get a little bit broader. The definition of sex in this equal rights amendment that's on the ballot includes sexual orientation, gender identity, gender expression, pregnancy outcomes, and also protects against government actions that would curtail a person's reproductive autonomy or their access to reproductive health care. So it is broader than just saying gender or sex. Just so that everyone's aware, some folks may be at an organization that deals with a religious leadership or funding, religious institutions and freedom of religion. As you can see, the sponsors added a section, and this was a big part of the negotiations on this bill. Nothing in this section is intended to alter or diminish the existing protections for religion set forth in Articles 3 and 11 of the New York State Constitution. Emphasis is in the original, that all caps. So we also have U.S. Supreme Court cases on point here. The drafters of this legislation really attempted to ward off any clashes. Of course, if passed, we'll see how successful they are, but this is where we are right now, that it's not meant to alter other sections of the New York Constitution. Next slide, please, Kevin. All right, so with this changed current New York law, is this really an expansion of rights, and aren't these already codified in New York? As many of you know, the New York State human rights law prohibits discrimination already on the basis of age, race, creed, color, national origin, sexual orientation, military status, sex, and disability. It's in employment, housing, education, credit, and access to public accommodations. New York also has the Reproductive Health Act passed in 2019 and the Equality Act, which we often refer to as the Marriage Equality Act, and numerous other laws preventing discrimination in New York State. So nothing changes in the New York State human rights law or any of these other laws if this ballot referendum passes. This is all still here. This is nothing changes. It doesn't flex or change or alter it in any way. What it does is change the level of scrutiny that a court would look at in certain cases. So it would be a level of strict scrutiny, which is currently only applied to race, religion, national origin in New York. So what that means is any law or decision must be narrowly tailored to serve a compelling government interest. It's a higher level than currently for gender, age, and disability, and other the other enumerated things for the ERA draft. It's currently an intermediate scrutiny level, which just means it's not as high a bar. It has to serve an important state interest. It just gives us a little bit more of an even playing field, is really, as you could look at it. As it stands now, women and other groups don't have those same protections under the New York Constitution. Next slide, please. All right, so as I'm talking about this, many of you might be thinking, wait, is there a federal ERA? What happened to that? I just wanted to add that in, that it's not ratified. There are reinvigorated efforts to do so. And again, just to give you the perspective, this is not something rare and unusual or out of the blue. 85% of the UN nations have provisions like this in their constitutions, and another 115 have provisions that prohibit discrimination on the basis of sex. So you may be thinking, wait, I thought we had an ERA in New York. Well, we don't currently. Or you may be thinking, what happened to the federal ERA? So that's still actually in question, and that may again resurface. So we'll keep you informed on that as well. We just want to give you the concept that this isn't something new. In fact, in New York State, the first time the ERA was introduced was 1923. And of course, the federal ERA really had a big movement in the late 70s, early 80s. So this, again, this is just New York's version as it comes about. Next slide, please. So what does New York's ERA do? Again, this is a referendum on the ballot in November. If adopted, it would add existing enumerated protections, which means just outlined protections of adding sex, disability discrimination, and age into the Constitution that already has those based on race and religion. It would explicitly prohibit this based on their ethnicity, national origin, age, disability, and sex. And again, sex does have a broader definition, including sexual orientation, gender identity, and others. This provides the strongest level of legal protection against discrimination. The key is, and really what the proponents are talking about, is that a constitutional amendment is tough to do. It takes 2 legislative cycles, signing by the governor, then a vote of the people. It takes several years to have this happen. So it cannot be changed quickly. What it would do is make it harder to eliminate or narrow existing legal protections. And as the name states, it provides equal protection to women or others in the Constitution, where it currently isn't actually outlined. Next slide. Thanks, Kathy. All right. So will this directly impact everyone? The discrimination laws are already codified in New York State. We have the New York State Human Rights Law, which I read. It's very broad. It covers a great deal. We have many other protections as well. And some of these protections are already in the New York State Constitution. If this were to pass in November, it's not going to have any kind of immediate, like everything changes effect. It's not actually going to have any effects like that. It would elevate the level of scrutiny in certain court reviews, typically government decisions or laws, if those are brought forward. So it's not something that would immediately change anything. We already have all those laws that we have to comply with in New York State. What it does is it just sort of solidifies those and strengthens them a little bit. It could lessen frequent changes to the law. We see this sometimes on the federal level and also on the state level. As different people take office, laws change, making it harder to keep up for some folks. Obviously, you could always call the folks at Bonds to help you with that. But it just makes it so that there's less frequent changes. There won't be immediate changes, nothing in particular to prepare for. We just wanted to make sure people were aware that this was happening. The bottom line is you follow the current anti-discrimination laws, policies and practices you have in place, train your team to do the same. And if passed, nothing will really change on your end of doing business.
Thanks, Kim.
Yeah, thanks so much.
Okay, so moving on to our final presenter, we have Devin Carris, who is in our New York City office, part of our team of employee benefits attorneys at Bond. And I understand, Devin, you'll tell us more, but I understand there's been a change in the law requiring certain coverage for certain part-time employees. So I will look forward to hearing about that here. So go right ahead with your presentation.
Great. Thanks, Kristen, for the handoff. Good afternoon, everybody. My name is Devin Carris. I'm Senior Counsel at Bond, Schoeneck King's Employee Benefits Group, where we sort of handle everything soup to nuts regarding employee benefits issues, whether they concern health and welfare plans, pension and retirement, executive compensation, plan correction, sort of the whole kit and caboodle on employee benefit and ERISA governed plans. We're a one-stop shop for those sort of questions. The topic today is something called, it's a new rule that was effective 1/1/2024. It's a new mandate under the Setting Every Community Up for Retirement Enhancement Act of 2019. And Kathy, you can go to the next slide. People don't want to look at my face. So the Secure Act of 2019, there's two Secure Acts, actually. There's what I call the OG Secure Act from 2019, which is the legislation that we're going to be part of the legislation that we'll be discussing today. And then there's the Secure Act of 2022 that was passed, obviously, in 2022. And the goal of each sort of piece of legislation was to sort of enhance retirement coverage and make retirement slightly more accessible for people. I'd say that the 2022 Act, or the Secure Act 2.0, as they call it, is more comprehensive in terms of the expansiveness that's allows employers to take part of. But as I said, we're talking about the OG 2019 Act today, which includes a new requirement with respect to long-term, what are called long-term part-time employees. And effective 1/1/2024, all plan sponsors of a 401k plan have to allow their long-term part-time employees to make an elective salary deferral to a 401k plan, again, as of the first day of the applicable plan year. So for non-calendar plan years, if it's a June 1 start date, it would be as of 6/1/2024. But for calendar plan year sponsors, the requirement that sponsors allow their long-term part-time employees to make elective deferrals was effective 1/1/2024. So what is a long-term part-time employee? So for the first year of implementation, a long-term part-time employee is any employee who's worked at least 500 hours, but less than 1,000 hours in the preceding 3 consecutive 12-month periods. So, for example, if you've got a calendar year 401k plan, you would be counting, if someone worked 500 hours in 2021, 2022, and 2023, if they meet those requirements, if they work 500 hours each of those years, then beginning 1/1/2024, the plan sponsor is obligated to offer that employee the ability to make elective salary deferral contributions under their 401k plan. I note that this 3-year look-back period is short-lived. The Secure Act 2.0 truncated that look-back period from 3 years to 2 years, beginning in 2025. So this is kind of something that you want to be mindful of as we roll into the next year. And I know it's only February, but we want to start thinking about that ahead of time to kind of get the ball rolling. Also of note for sponsors of 403B plans, which is obviously not 401k plans, the long-term part-time employee mandate will be applicable to 403B plans as well. That may be less of an issue because 403B plans have something called the universal availability rule, but it is something to be mindful of as we roll into 2025. And I'm sure as we approach the new year, you'll be getting alerts, or feel free to reach out to view the Bond website for updates, because I know we'll be alerting people on that. So next slide, please. So as I indicated, the new rules were effective 1/1/2024, but there was very little guidance until late 2023 on how to implement this new rule. And a lot of practitioners and plan sponsors were left scratching their heads until late November, early December of 2023. And exactly, how does this rollout take place? The effective date's 1/1/2024. How do we take advantage of this, and what are we supposed to do? So proposed regs were issued late last year. For those of you that are masochists and would like to read the proposed regs, you can find them at 88 Federal Register 82796. And they'll have all the details that we'll be kind of brushing over and giving a very high level view this morning or this afternoon. So some of the questions that were answered in the proposed regs, we're going to go through those now, but one of the questions was, well, can we exclude anybody from the long-term part-time mandate? And the answer is yes. However, it's the categories of excludable employees are not that broad. So of course, we can exclude people who fail to meet the 500 hours for 12 consecutive months for 3 consecutive years requirement. So for example, if someone worked 500 hours in 2021, but only 300 hours in 2022 and 800 hours in 2023, you could exclude that person because they did not work 500 hours for 3 consecutive years for the look back period beginning in 2021. Another category of people that can be excluded are collectively bargain employees and non-resident aliens with no U.S. source income. They can be excluded as well. And then, of course, there's the general sort of non-discriminatory classification. So as a general rule, 401k plans can exclude employees that work at a different location or a different plant, but the classification would have to be on a non-discriminatory basis. And getting into those non-discriminatory basis rules would kind of eat up most of the day, probably. They're that complicated. Another sort of talking point or question that was addressed in the proposed regs that were just issued late last year was the measurement period. A lot of practitioners ask, well, what is it says it's a 12-month measurement period beginning as of 2021. When does that begin and end? Under the proposed rules, the measurement period is for a new hire, it's the first day of the first hour of service from which you would count the 12-month period. So if someone starts in March of 2021, for example, the 12-month period would be March 2022. However, for purposes of administrative convenience, plan sponsors can shift any subsequent year to the plan year. So it would be, 12-month period beginning March, but then you could switch it to January to comply with the plan year measurement period. Excuse me. So next slide, please. The next topic is going to be regarding counting hours. So we know what the measurement periods are going to look like. The next question is, well, are we obligated to count each hour worked for these long-term part-time employees? You're not obligated to. If you don't have a different method of counting hours under the plan document, that's probably considered the default rule. So if you don't have sort of a different plan language that allows for an alternative acceptable method of counting hours, which we're going to discuss right now, you'd have to count actual hours worked during each look back period. As a somewhat of a reprieve, their 401k plans allow something called to count hours. They allow something called the hours equivalency method, where you can allocate a deemed set of hours worked based on a specific kind of period. So, for example, under the elapsed time method for a 401k plan, you can have, if you got a long-term part-time employee and they work 2 hours, at least 2 hours during a week, you can automatically deem them having worked 20 hours during that week or 40 hours during that week, depending on what your plan document says, provided it's compliant with the code. You could deem a number of hours worked for that week in which they worked you're certain that they worked 1 or 2 hours. That's one way to get around having to count actual hours for each year for each long-term part-time employee. So consult your plan document to see if you allow for use of the elapsed time method. I'm sorry, the hours equivalency method. Another question of way of circumventing having to count actual hours worked is something called the elapsed time method. And the elapsed time method has a very strict definition, which indicates essentially that you have to, if someone is working for an employer for a year, that during an elapsed time period of a year, you have to automatically allocate that person 1,000 hours of service during that year. And under ERISA, there's a minimum, if you work 1,000 hours of service during a 12-month period, you basically have to make that person eligible for purposes of the plan. So if you apply the elapsed time method for long-term part-time employees, yes, you can, but then you're basically making them immediately eligible as a normal employee, not as a long-term part-time employee. And that you would count them as a normal eligible employee. And essentially the rule or the long-term part-time employee rule would be swallowed up by the elapsed time method of counting them. They're now essentially deemed a regular eligible employee as opposed to a special long-term part-time eligible employee. So it's not recommended to use the elapsed time method for purposes of counting hours worked for your long-time part-time employees retrospectively. Next slide, please. Another question that was addressed in the proposed regs that were issued late last year was, what happens to these people? Is there something called the break in service rules? Those apply to long-term part-time employees. The answer is no. Essentially, once a long-term part-time employee is deemed eligible to make elective deferral contributions to a 401k plan, they are in indefinitely to the extent that they're still employed by the plan sponsor. So if you've got someone who's now, they worked 500 hours for the last 3 years and you've offered them the opportunity to make 401k contributions, if in the following year they only work 200 hours during that year, they still have to be allowed to make salary deferral contributions. This kind of speaks to the policy rationale behind the Secure Act, and the Secure Act 2.0 is to make retirement more available for people that typically were not participating in their 401k plans. And it's to make sponsors more responsible for their, less actively involved employees. And so that's why we have the once in, never out rule. Another point that was addressed in the proposed regs is that these are the long-term part-time mandate is for 401k elective deferrals only that are made by the long-term part-time employee, which means that a plan sponsor does not have to allow catch-up contributions, Roth contributions, or after-tax voluntary contributions to be made by this sort of unique subset of people. So it's very limited in the scope of who's required and what they're allowed to do. So it's hopefully the burden isn't too heavy for plan sponsors. But again, an employer can make it more expansive if they choose to. I don't know if they would want to, but as I noted, the rule is limited to 401k contributions primarily. Another question that came up was regarding employer contributions. Can an employer make employer contributions in the form of a matching contribution for long-term part-time employees or non-elective employer contributions? The answer is yes. However, it's complicated by the fact that if you're going to be making matching contributions or non-elective contributions for certain numbers of these people, these long-term part-time employees, they would have to be receiving a full vesting year, even though they're only working 500 hours in that year. So that might engender some political issues, some, resentment, I suppose, if you've got long-term part-time employees that are only working 500 hours and they're eligible for a matching contribution and they're already vested. So that's something worth considering closely if a sponsor is looking to add or make employer contributions available to their long-term part-time employees. Lastly, what was addressed was plan testing. And if you've got a safe harbor 401k plan, to avoid having to make these individuals eligible for safe harbor matching contributions and for, to avoid testing, the plan document would actually have to specifically exclude long-term part-time employees from the safe harbor aspect of the plan. So that obligation to expressly exclude long-term part-time employees from participation is not necessarily required for discretionary employer contributions, but for safe harbor plans, the plan document should say, yes, we're a safe harbor plan. We have safe harbor matching for all our employees except our long-term part-time employees that are expressly excluded from receiving safe harbor matches or safe harbor non-elective contributions. Something that's come up is that, sort of the timeline with this, right? The proposed regs came out late last year, and a lot of employers might have questions about whether they're, they might be behind the 8 ball on some of these things. They may not have made contributions or made long-term part-time employees eligible at this point. Mercifully, there's the employee plans correction resolution system that would allow employees to self-correct for things like this. As I said, the proposed regs, the comment period just closed in January, late January. And so my hope is that there'll be more guidance on plan corrections for employers that are a little bit late to the game on making this contribution available to their long-term part-time employees. And so essentially, what I would say is watch this space for more developments on this particular rule and on the Secure Act 2.0 and the Secure Act with respect to long-term part-time employees going forward, because we're anticipating a lot of guidance on those 2 bits of legislation for the rest of 2024. So that's it for my slides. I think that's it, Kathy. I guess the last one says thank you. I suppose I'm going to go to the last one. Oh, so yeah. So yeah, that's basically it for me. We're happy to address any questions you might have regarding implementation of these rules or any other rules regarding, as I said, Secure Act or Secure Act 2.0. And yeah, that's it. So thanks, everybody.
Thanks, Devin. Yeah, Kathy didn't flip to that last slide, but I think you already talked about it. And to our attendees, if you wanted to look at that slide, we do post the slides from this presentation on our website each week, so you can go back and take a look at that last slide. But thanks to all our presenters for being here today. Appreciate it. Here is their contact information in case you wanted to follow up with them on any of the things they discussed. And we will see you back again here in another week. On next Tuesday, Gabe will be here. Take care. Have a good afternoon.